My siblings voted me out of the family business without warning and kept every dollar. But when they saw I'd launched a competing company with $2 million in funding, my brother texted, "Let's be adults about this. Coffee Monday?" I forwarded it straight to my attorney. The email arrived at 6:48 on a Wednesday morning, which I know with precision because I was still in bed when my phone lit up with the subject line and I sat upright so fast that I knocked the water glass off my nightstand. The email was from a law firm I had never heard of, Prescott, Dane & Holloway, with a suite address in the financial district downtown, and the subject line said, "Formal notice of equity transfer and removal from management, Okafor Reese Specialty Foods, LLC." It was addressed to me by my full name, Kezia Amara Okafor Reese, not Kez, which is what everyone at the company had called me for 11 years. My full name, the way you address someone when you want to create distance between who they thought they were and what a legal document is about to tell them. I read the opening paragraph twice, then a third time, because my brain kept rejecting the sentences as incorrectly assembled. The language said that pursuant to Section 8.4 of the operating agreement, the remaining voting members of Okafor Reese Specialty Foods, LLC, had exercised their right to transfer my equity interest to the company itself at the formula valuation established in Schedule C, effective the prior Friday at close of business. Effective the prior Friday. 4 days ago, I had been at the company on Friday. I had sat in the weekly distribution meeting. I had reviewed the quarterly projections with our logistics coordinator. I had eaten lunch in the break room with 2 of our warehouse staff. I had, in every functional sense, been a co-owner and co-manager of that company on Friday, while somewhere, my brother Desmond and my sister Miriam were signing documents with a law firm I'd never heard of that erased 11 years of my professional existence. I put the phone down on the wet spot where the water glass had been and stared at the ceiling for approximately 4 minutes. Then I called my brother. He didn't answer. Then I called my sister. She didn't answer either. I got dressed, got in my car, and drove to the office. I had been building Okafor Reese Specialty Foods for 11 years when that email arrived. The company had started as our parents' idea, a small batch specialty condiment and prepared foods business rooted in the West African pantry ingredients our mother had spent her whole adult life hunting through 3 cities worth of import shops. She and our father had started it when I was 24, and Desmond was 27 and Miriam was 22, a kitchen table operation that made jerk-spiced cashews and Scotch bonnet hot sauce and a palm oil-based cooking base that our mother's friends in the community had been asking to buy by the jar for years. Our parents had run it beautifully as a small business, exactly the size it was meant to be until our father's health had made it impossible to sustain at even that modest level. He'd had 2 strokes in rapid succession when I was 27, and the business had needed someone to step in and either wind it down or take it forward, and I had stepped in. I want to be precise about this. I stepped in. Not Desmond, who was working at a marketing agency at the time and had 2 small children and a mortgage and reasons, legitimate reasons, to stay where he was. Not Miriam, who was in graduate school in Boston and had a year left on her program and her own reasons. Me. I left a job in food service consulting that had taken 2 years to establish, moved back to the city, lived for 3 months in my parents' house to manage my father's recovery and the business simultaneously, and began the process of turning a kitchen table operation into something that could survive past the founder. Over the following 8 years, I scaled the business from approximately $200,000 in annual revenue to just over $6 million. I brought in a co-packer, developed relationships with specialty grocery chains and regional distributors, rebranded twice, added 14 SKUs, and built an operations team that could run without my daily presence, though my daily presence was what I gave it for most of those 8 years anyway, because that's what building something requires. Desmond joined the company in year 5, when the agency work had dried up and the business had reached a scale where bringing in a marketing and sales lead made structural sense. Miriam joined in year 7, after her graduate program ended and she'd spent 2 years at a nonprofit that she'd found unsatisfying, in ways she'd been honest about. I had welcomed them both. And this is the thing I need to say clearly, because it matters for understanding everything that came after. I was genuinely glad they came. The business was our family's work, started with our parents' hands and our mother's knowledge, and having my siblings inside it had felt like completing something that had been waiting for them to arrive. I had given them both meaningful equity and meaningful authority over their domains, and I had trusted them the way you trust people you grew up sharing a kitchen with. The early warning signs, when I describe them now, have the obvious quality of things that are obvious only in retrospect. At the time, I had explanations for each of them, and the explanations were plausible enough that I accepted them and moved on. Because there's a particular resistance to suspicion that operates in family businesses that doesn't operate the same way in ordinary professional environments. You're not just reading a colleague's behavior, you're reading a sibling, and the interpretive template you use for a sibling runs much deeper than the one you'd use for a coworker, and it runs through memories and shared history and the fundamental assumption that certain betrayals are outside the range of what family does. That assumption, which I held with conviction until 6:48 on a Wednesday morning, was the most expensive thing I owned. The first sign was 18 months before the email. Desmond had suggested in a partners meeting that I'd called to discuss expanding our distribution to the Pacific Northwest, that we engage an outside consultant to evaluate the company's strategic direction. I had said I thought we knew our strategic direction. We were a premium specialty food brand with strong regional presence, and we were growing into adjacent markets. And he had said he thought an outside perspective would be valuable. It wasn't an unreasonable suggestion. I had agreed, but filed away the slight oddness of its framing. The consultant he engaged was a man named Philip Hartley, a business valuation and strategic advisory professional who I later understood, and I emphasized later, had a previous professional relationship with Desmond that predated his time at the company. Philip spent 6 weeks assessing the business, interviewed me at length, reviewed our financials, and delivered a report that recommended, among other things, a governance restructuring that would formalize decision-making authority along functional lines. His specific suggestion was that the CEO role, which I held, be redefined as a split authority structure with separate leads for operations, sales, and strategic development. It was presented as a professionalization of the governance structure. I had pushed back, said the structure we had was working, and that splitting authority without a clear integration mechanism was more likely to create friction than efficiency. The discussion had ended without resolution. I had filed it away. The second sign was a year before the email. Our company's banking relationship had been with a regional commercial bank, where I had the primary relationship with the relationship manager, a man named Gordon Fife, who had worked with me on the company's first business line of credit 7 years earlier. Desmond had suggested we explore moving to a different institution with better commercial lending terms, which was a reasonable operational conversation for a company at our revenue level. What was not entirely ordinary was that he'd already had preliminary conversations with the new institution before bringing it to me, and when I reviewed the documentation from those conversations, the primary contact at the new bank was listed as Desmond Okafor-Rees, with no mention of me. I had asked Desmond about this, and he had said he'd been introducing himself as the Sales and Business Development Lead, which was his title, and that, of course, any banking relationship would be jointly held. It had felt slightly wrong. I had accepted the explanation and told myself I was reading into things. That is the sentence I return to most often when I think about this period. I told myself I was reading into things. The morning I showed up at the company's offices after reading the email, I was in the parking lot before anyone else had arrived. I had a key, I had all the keys, my name was on the lease, and I let myself into the building and walked through the front office and into the conference room where we held the weekly distribution meetings, and sat down in the chair at the head of the table where I had sat for 8 years. And I looked at the room, and I thought, this is the last time you will do this. I don't know why that thought arrived so clearly and so quickly, before I'd even fully processed the legal situation. I think it was because some part of my professional instincts, the part that had spent 11 years reading situations and making decisions, already understood that the email was not the beginning of something that could be reversed. It was the completion of something that had been built over a long period, carefully, specifically, in the direction of this outcome. Our operations manager, a woman named Fatou Diallo, who had been with the company for 4 years and had the particular loyalty of someone who has watched a business grow and feels invested in its survival, arrived at 8:15 and stopped short when she saw me sitting in the conference room. Her expression told me that she knew something. Not everything, but something. She said, Kez, just my name. I asked her what she knew. She sat down slowly and told me that on the previous Thursday, the day before whatever had happened legally had taken effect, Desmond had called a staff meeting and told the team that there were going to be some changes in leadership structure, that the company was entering a new phase, and that Kezia would be transitioning out of her role. He had said transitioning out like it was a mutual decision that had been announced to me before it was announced to them. Fatou said she had assumed I already knew. She said she had been waiting for me to call. Her eyes were wet in a way she was trying to control. I told her she didn't need to be upset. She said, I built 4 of those SKUs with you, Kez. I know what you put into this. I thanked her. I went back to my car. I drove to a coffee shop 3 blocks away and called a business attorney. The attorney I called was recommended by my personal lawyer, a general practice attorney named Obiora Nwosu, who I'd worked with for years on personal legal matters, and who, when I called him in the parking lot of the coffee shop at 9 in the morning, describing what I'd found in my email, said with the precise urgency of someone who understood what he was hearing, you need a business litigation specialist before you do anything else. Do not respond to the email. Do not enter the building. Do not communicate with your siblings. I'm going to give you a name, and I need you to call it now. The name was Daphne Adeyemi Cross, a partner at Adeyemi Cross & Lowe, who had 22 years of experience in business litigation, with a specific focus on closely held business disputes and minority equity holder rights in LLC structures. She had, according to Obiora, a record of particular effectiveness in situations involving operating agreement violations and improper equity transfer mechanisms. I called her office at 9:08. Her assistant put me through within 6 minutes, which told me Obiora had already called ahead. Daphne Adeyemi Cross had a voice that was both warm and very precise, and she listened to my account without interrupting for 11 minutes, and when I finished she asked 2 questions. The first was whether I had a copy of the operating agreement. The second was whether I had ever been given any written notice of an intent to exercise the equity transfer provision under Section 8.4. To the first question, yes, I had a copy. I had copies of every company document. I had kept meticulous records for 11 years. To the second question, no, I had received no notice. No written notice, no verbal notice, no indication of any kind that this was under consideration. She said, good. Then we have a significant procedural problem for them, because Section 8.4 of a standard LLC operating agreement typically requires advance written notice of 30 days before any equity action of this kind can be effectuated. If they skip that step, the transfer may be procedurally void. Email me the operating agreement before noon today. I was already at my car, already driving home to get the folder. The operating agreement, when Daphne reviewed it that afternoon, was better for me and worse for them than even I had realized. The company's operating agreement was a document I had negotiated with the assistance of Obiora and a corporate attorney 6 years earlier. When Desmond joined and we formalized the ownership structure with equity grants. I had been, at that stage, the majority equity holder. My ownership stake was 52%, Desmond's was 24%, and Miriam's, when she later joined, was 20%. The remaining 4% had been reserved for an employee equity pool that had never been formally activated. The Section 8.4 provision, the buyout mechanism that they had purportedly used to remove me, was a provision I had insisted on including as a protective mechanism for minority holders, because I had wanted any buyout of a partner to be subject to fair process rather than arbitrary majority decision. The irony of that was not lost on me. What the provision said, in summary, was that a buyout of any member could be initiated by a vote of members holding more than 50% of the remaining equity, that the initiating members must provide 30 days written notice to the affected member, including a statement of the formula valuation, that the affected member had 15 days to respond with a countervaluation if they disputed the formula, and that no transfer could be effectuated until either the countervaluation period had passed without objection or a dispute resolution process had been completed. None of these steps had been followed. There had been no 30-day notice. There had been no formula valuation communicated to me. There had been no opportunity to respond. The transfer had been executed according to the documentation Prescott, Dane, and Holloway had provided, as if the procedural requirements simply didn't exist. Daphne said when she called me at 4 o'clock that afternoon, they either didn't read the operating agreement carefully or they read it and decided they could move fast enough that you wouldn't be positioned to stop them. Either way, the transfer is procedurally defective and likely void. We're filing an emergency injunction tomorrow morning to freeze the equity transfer and prevent any further changes to the company's governance or assets pending resolution. I asked what that meant practically. She said, "It means they can't give your equity to anyone else, can't restructure the company, can't take on debt, or make major financial decisions until this is resolved. We're going to stop the clock right now." She paused. "Kezia, I need to ask you something. Are you still drawing a salary from the company?" I said yes, bi-weekly deposit. She said, "Check your account." I checked. The most recent deposit, which should have hit the previous Friday, wasn't there. They had stopped my pay on the same day the equity transfer took effect. I am including this detail not for dramatic effect, but because it tells you something specific about the planning that had gone into this. The fact that the payroll change had been synchronized with the legal maneuver to the day of the week tells you that the person who organized this understood operational details down to the payroll schedule. Desmond handled payroll. He had taken over that function 3 years ago when we'd switched accounting systems, and he'd been the one to set up the new platform. I had given him that administrative authority because it was reasonable to give it to him, and because I trusted him. I keep returning to those words. I trusted him. They are the spine of the whole story. The injunction was filed the following morning by Daphne's associate, a focused young attorney named Julian Ease, who had 7 years of business litigation experience and the particular intensity of someone who understood that the first 24 hours of a dispute like this were often determinative. Judge Vivian Harlow, who was assigned to the matter on the commercial court docket, granted a temporary restraining order by 10:15 that morning, which froze the equity transfer and prohibited any major company decisions pending a hearing scheduled for 3 weeks out. Desmond called me at 11:42, 40 minutes after the TRO was served on Prescott, Dane, and Holloway. I let it go to voicemail. The voicemail was 2 minutes and 8 seconds of him saying that the company needed to move forward, that the decision had been made through the proper channels, that he hoped we could handle this as a family, and that he thought if I could just hear him out, I would understand the reasoning. He said the reasoning in a tone that suggested the reasoning was something I would accept once properly explained to me, as if the problem was my incomplete understanding rather than his and Miriam's conduct. It was a performance that would have been more convincing if I hadn't spent the last 24 hours reading the operating agreement and understanding exactly which steps they had failed to take. I forwarded the voicemail to Daphne with a note. "For the record?" She replied within 4 minutes. "Perfect. Keep everything." The financial picture that emerged over the following 2 weeks as Daphne and Julian worked through discovery and document requests was more complicated and more damaging to their position than the procedural violation alone. The company had, over the previous 18 months, made a series of financial decisions that I had been nominally informed about but whose cumulative significance I had not fully assessed. There had been a new line of credit opened in Desmond's name as primary signatory. This was the banking relationship change he had engineered a year before the ouster. There had been 2 distributions to members in the previous fiscal year that I had received in the standard course, but whose tax documentation I had not closely reviewed. When Daphne's financial forensics consultant, a man named Armand Tete, who had 18 years of forensic accounting experience and who I was told had worked on 3 previous closely held business disputes with similar characteristics, reviewed those distributions, he found something that changed the shape of the case entirely. The distributions had been calculated using 2 different valuation bases. My share of each distribution had been calculated using the formula valuation from Schedule C, the same formula that the equity buyout provision relied on, a formula that was conservative and used a revenue multiple methodology that consistently produced a lower number than market comparables. Desmond's and Miriam's shares of the same distributions had been calculated using a different, higher methodology, applied through an adjustment memo that appeared in the company's records, but that I had never seen and that my signature did not appear on. Over 2 distributions, the difference was approximately $84,000 that had been paid to Desmond and Miriam in excess of their proportional share at my expense. Armand presented this finding to Daphne in a 22-page report that she described to me in our call as the kind of thing that makes judges very attentive in hearings. She said, "This isn't just a procedural violation anymore. This is breach of fiduciary duty with financial damages that are now documentable. We're amending our complaint to add breach of fiduciary duty and conversion, and we're increasing the damages claim." I asked what the conversion claim was. She said conversion was essentially civil theft, the wrongful taking of property belonging to someone else. She said it with the satisfaction of someone who had found the right tool for a specific job. My parents learned about the legal situation from me in a phone call I made the evening after the TRO was granted. They were both in their 70s now. My father slowed considerably from the strokes but still present and clear. My mother, with the sharpness of a woman who had spent 40 years in a country that was not the one she'd grown up in and had learned to read situations clearly as a matter of survival. I told them what had happened, plainly and without embellishment, not because they deserved the truth and because I was not going to manage their reaction. They were adults who had built the thing that was now being destroyed, and they had the right to know. My father was quiet for a long time after I finished. My mother was not quiet. She said things in Twi that I understood directionally, if not word for word, and then she switched to English and said, "Kezia, you built that company. Your father and I started it, but you built it. You know what you put in. Well, don't let anyone tell you the story any differently." I told her I wouldn't. She asked what she and my father could do. I said there was nothing to do right now except not speak to Desmond and Miriam about the legal situation, which I knew would be difficult, but which Daphne had advised was important. My mother said she was not sure she could not speak to her own children. I said I understood. She said, "But I have nothing to say to them right now that a lawyer would want me to say," which was, I thought, a reasonable resolution. My father said, in the careful way he had spoken since the strokes, "You are going to be all right, Kezia." Not a question, a statement. From a man who had built something with his hands and watched his children carry it, and who understood better than most that what you build is not always the thing that defines you. The building is. I thanked him. I got off the phone and sat in my apartment and thought about what came next, because the legal process was moving, but I was 35 years old and I had spent 11 years building a business that had been taken from me. And the lawsuit would eventually produce a resolution, but a resolution was not a future. I needed a future. I started thinking about one. Let me tell you what I knew that Desmond and Miriam didn't know I knew, because this is the part of the story that matters for understanding what happened next. I had spent 11 years in specialty food. I had built every one of the company's supplier relationships from scratch, many of them through personal connections that predated the company's existence, relationships with importers, co-packers, specialty ingredient suppliers, retail buyers. I knew the unit economics of the category better than almost anyone in our market. I knew which SKUs drove margin and which ones drove volume and why the distinction mattered for a business of our size. I knew where the gaps in the specialty foods market were, because I had spent 11 years navigating them. And I knew something that Desmond and Miriam had apparently not considered carefully enough. Every single one of those relationships was mine, not the company's. Not contractually, not exclusively, not in any way that appeared in the company's books. The suppliers knew me. The retail buyers knew me. The co-packer we used had originally been brought on because the owner, a woman named Vivienne Asante, who ran a specialty food manufacturing operation in the eastern part of the state, had trusted me specifically after 3 conversations and a plant visit. Vivienne had not been cultivated by Desmond. She had been cultivated by me over 18 months of relationship building. You at trade shows and on the phone and over lunches where we talked about the market and about her business and about what a partnership could look like. The day I drove home from the family company's offices for the last time, the day of the email, I had called Vivienne before I called Obiora, not to discuss business, just to tell her what had happened. She had said in the directness that made her someone I trusted, "What are you going to do?" I said I didn't know yet, but I was thinking about it. She said, "When you figure it out, call me." That call happened 6 weeks later. The competing company was not an impulse. I want to be clear about that because when I eventually described the timeline to people, there was sometimes an assumption that I'd made a reactive emotional decision, and that's not accurate. The legal situation created a period of enforced distance from my prior professional life while the lawsuit moved through its preliminary stages, and I used that time deliberately and with the kind of focused attention I'd always brought to problems that deserved it. I talked to Vivienne Asante about what a manufacturing partnership could look like with a new entity. I had conversations with 4 of the retail buyers I'd built relationships with, framed carefully around understanding the market rather than soliciting business for something that didn't yet exist. Conversations that told me what I needed to know about where the opportunity was. So I reached out to a woman I'd met 3 years earlier at a specialty food trade show, a former brand strategist named Priya Olawale, who had worked on 2 successful food brand launches and who had told me then, in a conversation I'd been thinking about ever since, that the market for West African pantry ingredients in mainstream American retail was dramatically underserved relative to comparable categories. Priya and I had coffee in early January 2 months after the email, and we talked for 3 hours about what a purpose-built brand in this space could look like if it were built from the beginning for scale rather than for the niche regional market my family's company had been designed for. At the end of the conversation, Priya said, "Are you actually going to do this?" I said I thought I was. She said, "I'll come with you." We shook hands across a coffee shop table, and that was the founding moment of Acoma Foods. The funding round was the part that required the most effort in the least amount of time, because Priya and I decided early that we needed to move quickly. Not frantically, but with the deliberate speed of people who understood that the window for a first-mover advantage in a specific market is not open indefinitely. I put together the pitch deck myself, working from my 11 years of operational data and market knowledge, and I pitched 17 investors over a 6-week period between late January and mid-March. Some said no immediately. Some asked good questions and said no anyway. 3 said yes, and the 3 who said yes collectively committed $2,040,000 in seed funding, also which closed in the 3rd week of March, 7 months after the email from Prescott. Dane and Holloway had arrived on my phone at 6:48 in the morning. The 3 investors were a specialty food-focused venture fund called Larder Capital, whose founding partner, Amara Johansson, had 10 years of food industry operational experience before going into venture, and who I had met at a trade show 2 years before and stayed in contact with. An angel investor named Clifton Osei Mensah, who had made his first money in food distribution, and who had been referred to me by a mutual contact, and a family office that invested specifically in consumer brands founded by entrepreneurs from underrepresented backgrounds. The close was on a Thursday morning, the documents were signed electronically through a process that took 12 minutes, and the wire confirmation arrived at 10:42 a.m. I was sitting in the co-working space that Priya and I had been using as a temporary office, and I forwarded the confirmation to Priya and then sat with my phone in my hand for a moment and allowed myself to feel something, because there are moments that deserve to be felt rather than managed. Then I called Daphne Adeyemi Cross to update her on the status because the funding close was relevant to the lawsuit in a way that I'll explain. I had not told Desmond or Miriam about Acoma Foods. This was deliberate, and it was Daphne's counsel as much as my own instinct. There is no obligation to disclose a new business venture to former business partners, and the lawsuit had not yet reached a stage where the existence of a competing company would be directly relevant to the claims being adjudicated. The lawsuit itself was moving. Depositions had been scheduled, Armand Tete had submitted his forensic accounting report as an expert disclosure, and Prescott, Dane, and Holloway had filed an answer to our amended complaint that was notable primarily for what it didn't deny. It didn't deny the procedural defects in the equity transfer process. It argued instead that those defects were harmless because the substantive decision to remove me had been properly made by the required voting majority. Daphne had responded with a motion for summary judgment on the procedural void claim that was pending before Judge Harlow. The hearing on that motion was set for 5 weeks out from the funding close. None of this required my new company to be known to them, but my new company, as it turned out, became known to them through a mechanism I had anticipated, but whose timing I hadn't controlled precisely. Priya Olawale had a professional social media presence that she had been building for years, and she posted about the Acoma Foods funding close the day it happened. A careful professional post that described the company and the investment without naming specific investors, but that used her name and mine and the company name in a way that anyone who searched for either of us would immediately find. She had told me she planned to post, and I had said yes, because we had nothing to hide and because frankly a seed round announcement is marketing. I did not expect it to travel as far as fast as it did. By the following morning, the post had been reshared by Larder Capital's feed and by 2 food industry publications that aggregated funding announcements in the specialty food space. By that evening, a brief item had appeared on a trade industry website with the headline, Former Okafor Reis Specialty Foods co-founder launches competing brand with $2 million in seed funding. Desmond texted me at 8:23 the following morning. Kez, I saw the news. Think we should talk, figure this out like adults? Coffee Monday? I read it at 8:31, and the specific feeling I had reading it was not triumph and was not anger, though both of those were present in the general atmosphere of my response. What I felt most precisely was the particular clarity of seeing something confirm itself exactly as you had expected it to. When the text was what I had known the text would look like whenever it arrived, the sudden return of informal address, the let's talk like adults, framing that implicitly accused me of the childishness, the specific day of the week proposed with the ease of someone who still thought the relationship dynamics ran in his favor. I forwarded it to Daphne at 8:32 with 4 words. For the record. She responded immediately. Perfect. Keep your phone charged. The hearing on Daphne's summary judgment motion happened on a Thursday morning in April in Judge Vivian Harlow's courtroom on the 4th floor of the county courthouse, in a room with high windows and the specific institutional quiet of a space where serious decisions are made regularly enough that the room itself has absorbed their gravity. I was dressed carefully and appropriately, which is something Daphne had mentioned exactly once. Dressed like a professional who built a company, not like a plaintiff, and which I had taken to heart. Desmond and Miriam were seated at the opposing table with 3 attorneys from Prescott, Dane, and Holloway. I had not been in the same physical space as either of my siblings since the morning I'd arrived at the offices to find Fatou Diallo, with wet eyes and the word transitioning still in the air. Sitting 12 feet from them in a courtroom was, I want to be honest, one of the harder things I've done, and the difficulty was not about anger, it was about grief. The grief of sitting in a room designed for adversaries across from people who grew up in the same house as you, who share your parents' hands and your parents' language and your parents' history of building things in a country that was not always welcoming of the building, and understanding that they looked at all of that and decided it was worth sacrificing for an advantage they had calculated incorrectly. The oral argument lasted 80 minutes. Daphne was precise and unhurried, walking Judge Harlow through the operating agreement provisions, the procedural requirements, the documented absence of notice, and Armand Tete's forensic findings about the distribution calculations. The Prescott, Dane, and Holloway attorney, a senior partner named Griffith, who with the practiced fluency of someone who had made these arguments before, argued that the procedural defects were curable and that the equitable outcome was to allow the substantive decision to stand while remedying the process. Judge Harlow asked him at one point in the dry tone of a judge who has already formed a view and is testing whether anyone can change it. Counsel, are you arguing that the operating agreement's notice requirements are optional, or are you arguing that your clients simply failed to follow them and the court should overlook that? Griffith said they were arguing the former. Judge Harlow said, I'll take the motion under submission. I'll have a ruling within 10 days. She did. 6 days later, Daphne called me at 2 p.m. with the ruling, which held that the equity transfer was procedurally void and had no legal effect, that my 52% equity interest in Okafor Reis Specialty Foods remained intact, and that the defendants were ordered to restore me to my management position pending resolution of the underlying dispute, and were additionally sanctioned for the improper distribution calculations with a preliminary damages finding of $112,000, representing the underpaid distributions plus interest. Daphne read the key paragraphs to me over the phone in the careful, exact manner of an attorney delivering good news without overstating it. When she finished, I said, What happens now? She said, Now they have to decide whether to settle or go to trial. knowing that the procedural question has been decided against them, and the fiduciary duty claims are very strong. My professional expectation is that you'll have a settlement offer within 3 weeks. She was right, with a margin of about 4 days. The settlement offer arrived through Prescott, Dane & Holloway, 19 days after Judge Harlow's ruling, in a letter that Daphne described as the letter of people who understand they have lost the case, but need to negotiate the degree of the loss. The opening offer was a buyout of my equity at a valuation that was somewhat above the Schedule C formula, but substantially below what Armand Tete had valued the company at using current market comparables. It also proposed a non-compete provision that would have restricted my activities with Acoma Foods for 3 years in several categories. Daphne rejected both elements and made a counter-proposal. I would accept a buyout because at this point I did not actually want to return to running a company with people who had done what my siblings had done, but the buyout price would be based on Armand's market comparable valuation, not the formula that had already produced a fraudulent distribution calculation, and there would be no non-compete, full stop, because they had forfeited any reasonable basis for a non-compete the moment they executed an improper equity transfer and an improper distribution scheme. The negotiation took 11 days and 3 rounds of counteroffers. The final settlement agreement was signed on a Thursday afternoon in May, and its terms, which I am able to discuss because it was not a confidentiality sealed settlement at my insistence, included a buyout of my 52% equity interest at a valuation of $3,800,000, which was Armand's midpoint market comparable figure, payment of the $112,000 in underpaid distribution damages, reimbursement of my legal fees, which had reached approximately $214,000 by the time the settlement was finalized, and a mutual release of all claims. No non-compete. I signed the settlement agreement in Daphne's conference room with Julian Ease as a witness, and then I sat in the chair for a moment while everyone else gathered papers, and I thought about the email at 6:48 in the morning in October, and the wet spot on my nightstand where the water glass had been, and my father's voice saying, "You are going to be all right," and Fatou Diallo's eyes in the conference room, and Desmond's text about coffee. Then I picked up my pen and countersigned the certification page and slid it across the table to Daphne. Done. Acoma Foods was real, and it was growing, and it was mine in a way that Okafor Reis Specialty Foods had never been entirely mine, because I had always been managing it in relationship to its founding story, and to my parents and to my siblings who came later, and the weight of that relationship is not a complaint. It was also a gift, but it was a different thing from standing inside something I had built with my own particular vision from the ground up. Priya Olawale and I had used the 8 months of the legal process to build Acoma Foods with a focus and speed that the money and the manufacturing relationship with Viviana Asante and the retail relationships I brought made possible in a way it might not have been for people starting without those assets. By the time the settlement cleared, we had 3 SKUs in production: a Scotch bonnet pepper oil, a Suya spice blend, and a palm kernel cooking base, and letters of intent from 4 specialty retail buyers, 2 of them chains with regional footprints that Okafor Reis had never accessed. Our target was national specialty retail in 24 months. The seed money gave us runway to scale production to that level if the early sales validated the unit economics, and the early sales were validating the unit economics. Priya was the brand genius. She had a visual language for the packaging and the marketing that was doing something different from what other brands in the category were doing, rooted in aesthetic confidence rather than ethnographic explanation, designed for a customer who wanted premium quality and wasn't looking for a geography lesson. I handled the operations and the supplier relationships and the retail strategy. We were, as a founding team, well matched, and I knew it and was grateful for it in a way that I hadn't always been grateful for things that were going well, because going well is easy to take for granted until you've sat in a parking lot at 9 in the morning holding a legal notice that says you've already been erased. The relationship with my siblings is the part of this account that I find most difficult to characterize accurately, because I want to be honest about it, and honest doesn't mean simple. I did not, in the aftermath of the settlement, feel the specific kind of closure that stories about family betrayals are supposed to generate. I felt something more chronic and less resolved than closure, a kind of permanent reorganization of the emotional landscape, where the people who had been fixtures in it were still present but in different positions than before, further back, occupying a different kind of space. Desmond called me twice after the settlement was signed. I answered the second call. 3 weeks after the first one, I'd let go to voicemail. He said he was sorry. He said it in the way people say it when they mean, "I'm sorry this went the way it did," rather than, "I'm sorry I did what I did." I heard the distinction, and I said I appreciated him calling. He said he hoped we could have a relationship. I said I hoped so too, which was true, in the specific sense that I hoped someday we could be in the same room without the weight of what had happened being the primary thing in it. That day had not arrived yet, and I was not going to pretend it had. He asked about my parents. I said they were well. He said he'd been talking to them. I said I knew. He said he was glad. That was most of the conversation. It was not the conversation from the texts, the coffee conversation, the let's be adults conversation, and I was glad it wasn't, because adults do not propose casual coffee after what he had done. So again, forwarding that text to Daphne had been the most adult thing I had done in the entire situation. My mother called me on the morning after the settlement funds cleared, which was a Friday early in the way she called when she wanted to catch me before my day started. She asked how I was feeling. I said I was feeling like someone who had just gotten to the other side of something long and difficult and was still a little surprised to be standing. She said that was the right feeling to have. She said she had been thinking about what my father started in their kitchen, and about what I had carried forward, and about what Acoma Foods was going to be, and she said, "Your father says to tell you he knew." I asked what he knew. She said, "He says he knew from the beginning that the company was yours. Say that it was always going to be yours in the way that belongs to the person who builds it, not the person who names it." I held my phone and did not say anything for a moment, because some things require a moment to receive correctly. Then I said, "Tell him I'm going to make something worth naming." She said she would. She asked when she could try the palm kernel base. I said I'd bring some to Sunday dinner. She said she'd cook. I said I'd be there. The industry piece ran in a specialty food trade publication 6 weeks after the settlement, a profile of Akoma Foods and the story behind it, written by a journalist named Kweku Osei Nkrumah, who covered emerging food brands and who had found me through the seed round announcement. He was thorough and fair and asked exactly the questions I would have asked in his position, including the obvious one about how a company founded by a former executive of a well-known regional specialty food brand had access to production capacity and retail relationships so quickly at launch. I told him the truth, that I had spent 11 years building those relationships, that they were mine, and that when you leave a professional situation, regardless of the circumstances, you take with you the relationships you built and the knowledge you accumulated, because that's what professional history is. He asked if there was a legal dispute with the former company. I said there had been, and it was settled, and I wasn't going to characterize it further. He nodded and wrote something down and then said, with the directness of a journalist who is going to publish something regardless, "The word in the industry is that you were pushed out by your family." I said the word in the industry was accurate. He asked how it felt. I thought about that for a moment, a genuine moment, not a performance of consideration. Then I said, "It felt the way a structural failure always feels, which is both sudden and, in retrospect, not surprising at all. The thing I know now that I didn't know before is that what you build is not the building. The building is just evidence. What you build is the capacity, and you carry that with you." He used that quote in the article. I don't know that I would have said it so neatly if I'd had more time to think about it. But it was true, and the truth of it was something I had earned specifically and expensively, through the experience of having everything I had spent 11 years constructing stripped down to its elements and then discovering that the elements were still there. Still mine, still building. That is the whole story. Or rather, that's where the story's first chapter ends. The second chapter is happening now, in a production facility in the eastern part of the state that smells like Scotch bonnet and palm kernel and toasted spice, where Vivienne Asante's team is running our third production batch, and the numbers on the second batch's sell-through at retail are sitting in my email telling me that the unit economics are real and the market is real, and the thing I said I would make is taking shape. My father's hands are in it, whether he knows it or not. My mother's knowledge is in every formula. Priya's eye is in every label. And mine, 11 years of knowing this market, 3 months of not knowing what I was going to do next, and the particular clarity that comes from building something without the architecture of an existing thing to lean against. Mine is in the structure that no one can vote out, the structure that is not a company name or an equity certificate or a line of credit in someone else's name, the structure that is simply what you know how to do and that you carry with you everywhere, into the next room and the next building and the next morning at 6:48, when your phone lights up with whatever comes next.